Hello everyone, welcome to my YouTube channel Jury's Journey NCA Triumph and Canadian Law. So today's lecture is going to be very important, as in this lecture I'll be talking about the first topic of criminal law for NCA examination as a demo lecture. So many students have been requesting me to upload a demo lecture so that they can get an idea as how I'll be teaching in the course, as well as I'll be showing you the first topics complete notes in the form of sample notes. Also, towards the end I'll be talking about complete details on course, how you can enroll in it, how I'm going to take up the lectures. So now let's begin. So before moving with the lecture, I would like to humbly request you all that if you're new to my channel, haven't subscribed it yet, kindly do subscribe to it. So this is just a template. Towards the end of this lecture, I'll be talking about complete details on how I'm going to take up this course. So now let's firstly talk about the way I'm going to take up the lectures. So teaching is nothing new to me. I have provided over 200 selections in last 3 years for various Punjab government exams. So my aim is not only to make students just clear NC examinations, but to make you all prepare for real world practice and challenges. So the aim of teaching is not only to make things clear, but to make things interesting so that you can grasp every minute detail by heart. So firstly, in this lecture, what I have done, I have prepared a video. This video talks about the whole Canadian criminal law syllabus for NCA examination in the form of a storyline. So firstly, we'll go through this video, then we'll talk about all the topics that we have to do in order to complete the syllabus of NCA Canadian criminal law. So firstly, let's look into video.
The Journey Through Criminal Law, Unveiling the Secrets of Justice Act 1, The Genesis Stress. In the dimly lit halls of justice, our journey begins with the origins of criminal law, where we delve into the mystical realm of the sources of criminal law. Here, ancient codes, modern statutes, and judicial decisions intertwine to shape the very fabric of justice. Act 2, The Creator's Canvas. Behold, as we move forward, we witness the mighty wielders of the law who possess the power to create criminal offenses and craft the rules of criminal procedure. Through the power to create criminal offenses and rules of criminal procedure, we unravel the mysteries behind the procedural classification of offenses and learn the art of interpreting criminal provisions. Act 3, The Anatomy of Crime. With bated breath, we explore the elements of a criminal or regulatory offense. Here, the actus reus beckons us to scrutinize every action, while subjective mens rea reveals the hidden depths of intent. Objective mens rea and true crimes beckon, challenging our perceptions, while regulatory offenses lurk in the shadows, waiting to ensnare the unwary. Act 4, The Web of Liability. As the plot thickens, extensions of criminal liability come to light. Aiding and abetting, counseling, and attempts weave a tangled web of culpability. Corporate and association liability loom large, casting shadows of doubt upon the innocent. Act 5, The Shield of Defense. But fear not, for in our darkest hour the light of defense shines bright. Mental disorder, automatism, and involuntary acts stand as bulwarks against the tide of accusation. Simple intoxication and specific intent crimes dance a delicate waltz, while extreme intoxication and general intent crimes beckon us into the abyss. Act 6, The Arena of Adversity. With the dawn of the adversarial proceeding, we enter the arena of justice. Here, the adversarial process unfolds before our eyes as adversaries clash in a battle of wits and wills. Act 7, The Pursuit of Truth. Through the mist of criminal investigation, we follow the trail of evidence, where police powers reign supreme. Securing jurisdiction over the accused and interim release become paramount as the wheels of justice grind inexorably forward. Act 8, The Final Showdown. As we prepare for trial, disclosure and production become our weapons of choice. Preliminary inquiries, the jury trial, and pre-trial motions set the stage for the ultimate confrontation. Act 9, The Judgment Day. With bated breath, we await the pronouncement of judgment. General principles of sentencing guide the hand of fate, as appeals and review offer a glimmer of hope in the darkest of hours.
So now we have seen this video, I'm sure you must have get an idea of what this whole NCA criminal law syllabus talks about. So we started from history, and when we talk about history, the main topic, the first topic that comes into picture is the sources. So from sources, our Canadian criminal law syllabus starts. So let's look into all the topics one by one. So first topic, the sources of criminal law, from where we got this criminal law. So history. Then part to create criminal offences and rules of criminal procedure. Who can create criminal offences? Procedural classification. When we talk about creation of criminal offences, what kind of criminal offences? So are there hybrid offences, summary offences? So we'll be talking about classification of offences. Then interpretation, how we have to understand, apply, interpret the wording of these provisions, these criminal laws. Then next chapter comes into picture, that is elements of criminal or regulatory offences. So in the very first chapter, which has 4 topics, we talked about basic things, historical scenario, historical context, sources, interpretation, what kind of offenses. Now comes the major part, when we have to decide a criminal offense. The first thing that we keep in our mind is, was there any action? What was the mental state of the offender? So actus reus, then subjective mens rea, objective mens rea, true crimes, regulatory offences. Then extensions of criminal liability. So offences are not always as simple as they look. Sometimes we see that there are more than 2 persons involved. So aiding, abetted, whether there was only one offender or somebody has helped him in committing an offense. So counseling, attempts, was there completion of offense or was it only an attempt to commit a certain crime? Then corporate and association liability. What about if a company commits a crime? Who will be made liable? So next is one of the most important chapter, 100%. One of these defense comes directly indirectly in your examination. So there are various criminal defenses. So mental disorder, automatism, involuntary act, negativing the actus reus, the action of the crime, simple intoxication, specific intent crime, extreme general intent crime, defense of the person. In India, we call it self-defense. Then necessity, duress, provocation, entrapment, error of law, color of right. Then comes into picture, once we are done, once we have decided that whether there was defense or not, then comes adversarial proceedings, the plaintiff, the defendant, so all the court proceedings, police parts, getting to the trial. Once you are into court, so the trial starts, criminal investigation start, then comes into picture the police part. Then securing jurisdiction over the accused and interim release. What about bail? So then getting ready for the trial, disclosure, production, then preliminary inquiries, evidences, jury trial, pre-trial motion, then trial within a reasonable time application. Once we are done with the whole trial process, then last stage comes sentencing. Sentencing, again, very important topic. So one question you will get in the exam which will be directly related to sentencing. So you have to be into the foots of a judge and decide a relevant sentencing. Last is appeal of final decision, judicial review of interim decisions. So with this whole 32 topics journey, we complete Canadian criminal law. So we saw this in our video as well, the storyline. So starting from history, ends with appeal and judicial review. So this is how you have to keep things in your mind. So that is why I always say that before starting your preparation, give at least one complete day to understand the syllabus. Once you are familiar with the syllabus, once you have this whole story in your mind, then you are good to go with the preparation. So next is the materials. So when I did my preparation, I directly followed the textbooks. Steve Coughlin, Kent Roach, I prepared my own notes, but I know some students face shortage of time. So for the guidance, you can refer to any notes, any reliable notes that you feel you can refer for the examination. But still, I would suggest you to refer these material in your examination so that the answer checker should know that your material, your references, your justification analysis is from the textbook, is relevant, is factual, is clear and crisp. Because the Kent Roach book, even the Steve Coughlin, are more than sufficient if you want to do your preparation for NCA examinations. Trust me, nothing better than following these two books. Third thing that you must have in your hand while you are writing the examination is criminal code. So I would suggest you to use Martin's criminal code, but you can use any criminal code which is all the provisions, all the sections, because you are going to get at least one question in which you will need this. So they will be asking a section, then you have to go to the provisions, the exceptions, provisos, everything. So you will need only this criminal code for one exam, for one question, sorry, but that one question is important and you should have this criminal code, because you cannot afford to lose 30-40 marks in just one question because you don't have this criminal code in your hand. So this is must. So today in this demo lecture, I'm going to take up the first topic under the chapter General Overview and Criminally Matter, Sources of Canadian Criminal Law as demo lecture. So before moving with your reading, with your preparation, firstly go through syllabus of every topic so that once you are done with the topic from your notes or from your textbook, you can again go back to syllabus and check. I will be showing you how. So you can check that whether all the things that are mentioned in the syllabus I have done or not, or is there anything that is missing in the notes or missing in the book, so that you can follow some other external source, because whatever is mentioned in the syllabus, you have to do all these things, all these cases, sections, provision. You cannot miss even a single word. Even if sometimes there are indirect principles, legal tests, you have to do all those things. So firstly, let's read syllabus. What's mentioned on our first topic of sources, with the exception of contempt of court. So it means that here in the next line, we are not considering contempt of court. Whatever we are going to read in our next line, it won't apply on contempt of court. So with the exception of contempt of court, criminal offences are created in Canada by statute. Now, what does this mean? That generally criminal offences are created by statute like we have in criminal code, but talking about contempt of court, it is not given in any statute. Still, we follow it. So from where we follow it, that we'll look into later. Most criminal offences, most does not mean all. So this is how your interpretation comes into picture. Because we all are law graduates, this is the basic one can expect from us while going through the syllabus. So try to interpret all the words. So most criminal offences are created by criminal code, but it is not the only statutory source. What does that mean? It means that criminal code is not the only source. We have more than one source. So now two things have been clear in our mind. First, there is an exception of contempt of court. Secondly, we have more sources, more than one sources for criminal law. Because generally what happens when we see this criminal law word, only we talk about criminal code, but no, there are other things under Canadian law that are good main major sources of criminal law. So next line, drug trafficking, for example, is made a criminal offense by Controlled Drugs and Substances Act. So see, this is also another criminal offense, another source. So this is a statutory offense. And in which statute? This is not under criminal code. This is under another statute, Controlled Drugs and Substances Act. Common law cannot be used to create offenses. So here is the position of common law. Position of common law. What's the position? General position, we don't follow common law because of concerns related to principle of legality. Now, what is principle of legality? That I'll be talking about today in this lecture. I have mentioned this specific principle in my notes as well, because when I was preparing, I think bought 2-3 tutored sample notes just to have a look. And what I saw, that in all those 2-3 tutors note, principle of legality was not mentioned, was not defined anywhere, which I felt like they should have included, because I think all the things that are mentioned in the syllabus, you cannot miss on that. Usually it happens that you can check the like previous 5-year examinations. NCA might not have asked question on principle of legality, but that doesn't mean that we don't have to do it, whatever in the syllabus, because NCA keep on giving you surprises. Trust me. So you have to go through every minute detail that is mentioned in the syllabus. Word, you have to read every single word. So next is because of concerns related to principle of legality. So I talked about common law that usually we don't apply it. Reason. So reason is given in the next line. Reason is principle of legality. Then notion that criminal offenses should be clear, certain, pre-exist the act being prosecuted. So person should have this in mind whenever a person thinks of committing some crime. That person should know that if I do this thing, then these will be the repercussions, these will be the results, I will be prosecuted for this particular offense. So clear, certain, pre-exist act being prosecuted. So all these things are the reasons that are missing in the judge made common law. So that is why we don't follow judge made common law in Canada. As will be seen below, many rules of criminal procedure are created in criminal code. Many other rules of procedure are common law based. So when we talk about rules, so this is the main concept related to offenses. So the acts. Talking about rules, we follow both. So that we'll talk about later in the provisions in the case laws. While common law offenses are not allowed, common law defenses now. So common law position does not end there. Common law offenses are not allowed, but what is allowed? Exception again, defenses. We do follow common law defenses and can still be created by the courts. So here the position has been made very crystal clear. Supreme Court of Canada recognized a common law defense. So in which cases we have seen that Supreme Court has followed this trend of common law defenses. Levis City versus Tetrolt, officially induced error, was applied as a common law defense. Then R versus Mac, entrapment. We'll be talking about these cases in detail when we'll be taking up the chapter of defenses. Moreover, common law can deeply influence the way statutory criminal laws are interpreted, particularly mental element. So what else? Where else do we can apply the common law? So in the interpretation, in understanding the meaning. So now you have to see that how beautifully the syllabus tells you the whole story about a chapter. Then section 8 will talk about that clarifies the position of common law defenses, R versus Joe Biden case. So this was the syllabus. I hope you have got the main idea of what all we have to cover in this first topic of the sources of criminal law. So the very first thing from where we start this topic is by knowing what all are the main sources of Canadian criminal law. So we will be talking about three main sources. So first is Constitution. We all know that it's the supreme law of the land. nothing above this. So the Constitution, including both the division of power and the Canadian Charter of Rights and Freedom. So when we talk about division of power, it means that in order to create criminal law, the power has been divided between two levels of government. We know that Canadian government is a federalist government, which means we have one upper authority, the main union level of government, federal government, then every province has its own government, so which is provincial government. So the power is divided between federal and provincial. So in 1892, the Canadian Criminal Code has been formulated by the Parliament under the division of power which is given to federal government. So Parliament means federal government. So section 9127 talks about the power of federal government to create criminal offences. Then few small little powers like administration of justice have been given to provincial government as well. So for that we go through sections 92, 14 and 15. So we'll be talking about all these in detail in our next topic, but here you should keep these small little things in your mind. So first source, Constitution. Second, statutes enacted by legislatures, including criminal code, other statutes which create offences. So criminal code covers broad areas, broad spectrum of criminal behavior. We all know that. But there are certain offences like drug related crimes which are under different statutes. For that we have specialized statutes like the one which is directly mentioned in the syllabus, Controlled Drugs and Substances Act. So number one, Constitution creates criminal law, gives power to federal government to create criminal law. Then few parts have been given to provincial government. Then Canadian Charter of Rights and Freedom talks about few parts. Then comes at the second level. So that was on the first level. Second level comes the statute. So statute, the very first code is criminal code. Second is Controlled Drugs and Substances Act. So these are the main criminal law statutes. Third comes into picture judge-made common law. So in Canada, the judge-made common law does not create, so does not. I'm writing this in capital so that you can keep this in your mind. You can fit in your mind that common law has no position to create criminal offences in Canada. We only follow common law for three things. First, for what this has been considered as a source. So why we are talking about this as third source? Because judge-made common law, we use this in the form of defenses. So those defenses which are not codified anywhere in the criminal law, we follow common law. Simple for defenses. And secondly, we follow for contempt of court. And thirdly, we follow for few interpretations like mental element interpretations. We go back to case laws, then common law decisions, and we see what the courts have decided there. So we follow that. So these are the three main sources. So again, Constitution, number one. Second, statute. Number three, common law, but only for defenses mainly. So here I have given more elaboration on our very first most important source. So that is the Constitution, supreme law of the land. So let's quickly read. In Canada, the responsibility of criminal justice is shared between federal and provincial and territorial governments. So shared means few things have been assigned to federal, few have been assigned to provincial and other local level of territorial governments. So it's not like provincial should not take any kind of decision related to criminal law. So it's not like provincial has been kept completely aside from criminal law. No, the matters that are of local private nature, so the matters that include simple private rights, their provincial governments comes into picture. also for the administration, for the enforcement. So next is Canada's constitution give federal parliament the power to make criminal laws, and as a result criminal law then applies to the whole country. So whatever criminal law has been formulated enacted by the parliament at the federal level, that will apply to the whole of Canada. Thirdly, provinces and territories. So once federal government has created a criminal law, then the administration, the application, the enforcement part is given to the provincial and territorial governments. So provinces and territories are primarily responsible for enforcing the criminal law. This include, so what all can provinces and territories do while enjoying this power? So first, they can investigate into the crime. Second, they can prosecute most offenses and provide services, assistance, help to victims of the crime, like the rehabilitation and all those things. So fourth, criminal code was made law in 1892, as I told you in the previous slide, by Parliament of Canada. So Parliament of Canada means federal government. Federal government means section 9127. So this is how you're going to keep things in your mind. So with section 9127 of Constitution Act 1867, which gives federal government the power to make criminal laws in Canada. Furthermore, talking about this power, how can they enjoy this power? Because they have been given this power by the Constitution under section 9214. Next comes the position of a third important source, common law. What is a common law? So simply common law refers to the legal principles developed by judges through their court decisions rather than any statutes enacted by parliament. So whatever common law says, that is not written mentioned in any law, act, statute. So that has never gone through any parliamentary legislative proceedings. Simply common law comes from the courts, from the judge decisions. So this is the first thing that you have to keep in your mind. So what's the position? As I told you earlier while we were going through the syllabus, so I told you that common law, the reason for not applying this into Canadian criminal law, first is principle of legality, second is that it is not distinct, prior existed to the conduct. So principle of legality demands that criminal offences should be clearly defined by law. So now ask yourself a question. I told you, I explained you the meaning of common law. So do you think that common law justifies the principle of legality? Do you think common laws are clearly defined by law? So obviously a big no. So that is why what Canadian criminal justice system demands is principle of legality, which is not being satisfied by the common law. That is why we don't apply it in its real form to create criminal offenses. So this is what principle of legality demands. So if in exam you get anything related to this, so you have to mention the principle of legality. You can relate this with the facts of the proposition. So this suggests that people ought to be aware of the legal prohibitions on certain action as well as potential repercussions result for breaking those prohibitions. So this is important. Now, having said this, the next reason comes into picture that Canadian criminal justice system requires that crime must be distinct, definite prior to the conduct. So if I plan to commit murder, I should know that this is going to be the repercussion, that I'll be getting this much jail. So prior to the conduct being prosecuted, in order to preserve the legality concept, this makes sure that people are fairly informed. They should have this thing in their mind about what all kind of behaviors are forbidden in our soil, in our land, enabling them to adjust their actions to comply by the law. So this is the reasoning behind not following common law. So I hope this is clear. Now I would like to give you another example, so which will make things more clearer to you. So imagine you are navigating through a dense forest with clear signpost marking the boundaries of prohibited territory, that okay, this is a forest and you cannot go beyond this territory. So clarity and certainty in the law. So these things in the law and plus this principle of legality serve a similar purpose, guiding individuals from legal pitfalls and toward compliance. That okay, these are the boundaries of prohibited territory, you cannot go beyond that. So this is what the clearly defined laws, this is what Canadian criminal law does to you. So common law position that I talked before has been made clearer under the Criminal Code. Section 9 talks about it specifically. So it provides us few requirements, few prerequisites of criminal offences to be under law of Canada. What all things are required. So section 9 says, notwithstanding anything in this act or any other act. So notwithstanding means despite, in spite of, no person shall be convicted or discharged under section 730, which talks about sentencing of an offence at common law. So no person will be convicted or discharged if that person has committed an offence which is a offence under common law or which was an offence under common law. So whatever is an offence under common law is not a criminal offence under Canadian law. So this has cleared our position. Or of an offence under an Act of Parliament of England. So we are not even following these things, of Great Britain, UK, of Great Britain and Ireland. Third, offence under an act or ordinance in force in any province, territory, place before that province, territory, place became a province of Canada. So before that particular province, territory became part of Canadian land. So but nothing in this section. So now this is an exception. So nothing in this section affect the power, jurisdiction, authority that a court, judge, justice, provincial court judge had immediately before April 1, 1955 to impose. So whatever powers were given to the court's judges for punishing a particular person if that person has committed contempt of court, so that will continue. This won't affect the contempt of court. So contempt of court has been made an exception, that for that we do follow common law. So what is a contempt of court? Basically, contempt of court are all those actions that challenge the authority, the basic peace, decorum, or discipline or proceedings of a court. Like you are defying a court order, you are not following it, you are disrupting any ongoing proceedings in a court, or you are showing disrespect. So it means anything that you do against the court of law. So contempt of court. Now in common law, it is viewed as a transgression against the administration of justice rather than against an individual. So this is viewed as an offense, as a wrongdoing against whole system of justice. So consequently, courts handle it using their own inherent power to uphold order and ensure that the judiciary runs smoothly, its operations, working, administration runs smoothly. So section 9 of Criminal Code, as we read earlier in the previous slide, directly acknowledges towards the end as an exception that while contempt of court isn't explicitly outlined in any statutory law under Canadian criminal law, it is recognized as an offense under the common law, which we still follow. So this exception acknowledges that certain offenses, this is now important, such as contempt of court, are addressed through common law principle rather than through specific statutes, and which rather than through specific provisions that are outlined in the criminal code. So this you have to keep in your mind. So this is the position of contempt of court. Next comes very important case related to section 9 and how we don't follow the common law offenses in our today's criminal law. So Frey versus Fedrock, the first important case law. So firstly, let's read the facts of the case. So Frey was caught looking in a window by Fedrock and Stone, who proceeded to seize him. Fedrock, who was convicted at criminal trial, the action was overturned on appeal. Frey filed a civil suit for wrongful imprisonment. The defense argued the actions were justified because plaintiff breached the peace. So plaintiff breached the peace. Also, the defense fought for the decision of the trial judge in criminal case, stating that convicting Frey for an offense should be based on criminal responsibility of common law to apply generic principle to the fact of the case. Now, so is this scenario of just looking in a window, does this conduct of plaintiff enough to constitute a criminal offense? So can the court create criminal offenses? So here, because we are seeing that the trial judge is saying that convicting Frey for an offense should be based on criminal responsibility. So here we can see that there is no such already existing offense in criminal court, but we are trying to create an offense through the court proceeding, which we usually do in common law. So no common law history of peeping Tom being an offense, not even in criminal code. So you can see that because this is the case of 1950. So until 1953, no such offense under criminal code. So what happened? What was the analysis? So conduct being used as a predictor of potential for criminal behavior encroaches in fundamental rights and freedom and could lead to conduct like adultery, insulting someone, constituting criminal behavior. So this was the analysis that why they wanted to make this as an offense. So what happened? What was the decision? So the imprisonment was not justified as there was no proof that Frey had done anything in criminal nature, anything illegal. So just peeping, looking into a window of someone, so this is not a criminal offense. So decision of what is lawful is up to Parliament. So this has been made clear. The position of criminal offences under Canadian law has been made clear by this case, in which it was specifically held that if we have to create an offense, that is only the responsibility of the Parliament. Federal government can create criminal offences, the courts cannot. So appeal allowed with cost. So this was what happened in this case. So in simpler terms, Frey was caught looking through a window and the people who caught him claimed that he disturbed their peace. So they tried to convict him in a criminal trial, but the court said here that this was not enough proof that he did anything wrong. So the court also said that deciding what is legal is always the job of lawmaker, the legislators, the parliament, not of judges. So Frey's imprisonment wasn't right and he won the case. So now what is written in the Kent Roach textbook regarding this whole concept of section 9? So even before the enactment of section 9 of the criminal code, Kent Roach says that Canadian courts had always been reluctant to create common law or judge-made crimes on the basis that. So now what's the reasoning? What was always in the mind of Canadian justice system? Why we don't follow common law usually? That the common law would introduce great uncertainty into the administration of criminal law, leaving it to the judicial officer trying any particular charge to decide that the acts proved constituted a crime or otherwise, not by reference to any defined standard to be found in the court or in reported decision, but according to his individual view. So judge, according to his individual view, has to decide under common law as to whether such acts were a disturbance of tranquility, which means peace of people, tending to provoke physical reprisal. So this is the wording from Kent Roach, and this is related to the Frey versus Fedrock case. So the reasoning that has been given under the Kent Roach textbook to make you understand in more elaborative manner that why we don't follow common law. So see, if you relate things to the textbook wording, you can write your answer in a more elaborative, in a more engaging manner. So position of common law defenses. We talked about one part, one aspect, common law offenses cannot create, then one exception, contempt of court, yes. Now another important thing that comes into picture as per the syllabus is that one thing that we follow under Canadian criminal law from the common law directly is the defenses. So the position of defenses has been made clear under section 8, 2 and 3 of criminal code. So firstly, application of criminal law of England. So criminal law of England that was in force in a province immediately before April 1, 1995 continues in force in the province except as altered, varied, modified, affected by this act or any act of the Parliament of Canada. So we can follow the criminal laws of England that were in force in any province immediately before 1st April 1955. So what about common law principles? So every rule principle of common law that renders any circumstance a justification or excuse for an act or a defense to a charge continues in force and applies in respect to proceeding for an offence under this act or any other act of parliament except in so far, so in that basically sense in which we have altered uh, all those things which are inconsistent with this act or any act of parliament. So if not altered, then we'll continue to apply in its original form every rule or principle. So basically this talks about interpretation as well. So while the creation of new offenses under common law is generally not permitted, common law defenses remain relevant. So this is the position of section 8, 2 and 3 and can still be established, expanded by the courts. So this is only related to defenses and the interpretation principles and rules. So now comes second important case law, R versus Joe Biden, that is related to common law defenses. So firstly, let's look into the facts. So the defendant engaged in a fight with the victim who consented to it beforehand. So this is important, consent, because this is the main issue. So victim consented for the assault, for the fight. The defendant struck the victim once, causing him to become unconscious, fainted, although this was not immediately apparent to the defendant, who struck him several times before he fell into the hood of the car and collapsed. So the victim later died in hospital. So you can see this is not a simple harm. This is a very elaborative, extended version of a harm. So the question is whether there are any common law limitations which restrict, negate the legal effectiveness of consent. So in certain types of cases, if a person has given consent for assault, then there are common law limitations that restrict or negate. But the question is, do we follow this similar common law position into our Canadian criminal law? So here the court said that no, this is not the position in our criminal law. The defendant is definitely guilty of manslaughter because defendant might have given, the person who was the victim might have given his or her consent for a simple assault or for a simple fight like a fist fight, but one cannot do something that is completely illegal, a very aggravated form. So aggravated form of assault. because the person as a result of that fight died. So the defendant here is guilty of manslaughter. So let's read firstly the reasoning that was given by the Judge Gonther. So there are common law limitations for public policy reasons that would make what would otherwise appear to constitute agreeing or consenting to serious bodily harm not a legally effective form of consent. Though there is no crystal clear position in modern Canadian criminal law, so see this line. When one takes into account the combined English and Canadian jurisprudence, when one keeps sight of common law century-old persistent to limit the legal effectiveness, so this is a trend that has been followed under the common law. When one understands that Section 265, which deals with the assault, has always incorporated that persistence, the scale trips rather heavily against the validity of person's consent to infliction of bodily injury in a fight. Individuals are limited in their ability to consent to the intentional infliction of serious, non-trivial bodily harm in the context of, for example, fist fight. So if there is a case of fist fight, simply not we are not talking about any major aggravated form of fight or any serious bodily harm, so then we can take into picture the concept, but the principle that emerges from Joe Biden case, the limitation demanded by section 265 as it applies to circumstances of this appeal is one which negates, vitiate the consent between adults intentionally to apply force causing serious hurt, bodily harm to each other in the course of fist fight or brawl. So what does Kent Roach has to say on this? Despite the breadth of assault offense, no matter it's a big or small incident, and the clear exemption of consensual application of force from its ambit, Supreme Court has expanded the actus reus of assault by interpretation. So Supreme Court in this case of R versus Joe Biden, why did not take into account the consent given by the personal? Because here Supreme Court says that a person could not consent to an assault that intentionally, the other person is intentionally causing serious hurt. So it's not something that came out as a result of doing something. It is intentional. So, or non-trivial body harm in the course of a fist fight or a brawl, that a minor could not consent to an adult's intentional application of force in a fight. So these are the two situations where Supreme Court clearly stated that we are not going to follow the common law principle of negating, limiting a proper particular legal liability in a case where the other person, the victim, the second party, is already consenting for the assault. No, this is not a case. We can take into consideration this kind of things if the hurt is very, simple, non-serious, but if we are talking about proper assault, then we are going to look into whether the other person has committed the offense of assault intentionally. What was his mindset? Mainly, what was the actus reus? That's the first thing that we are going to see. So how much harm has been done? So what was the action? So it was a serious hurt which ultimately led to the death of the person. So in this case, consent cannot limit the legal liability of a person. So now we are clear with all sources of Canadian criminal law. We are done with the position of common law. We have seen that we don't apply common law for offenses. We do apply for three things: interpretation, defenses, and contempt of court. Now important question arises: are all these sources equal? The Constitution, the statute, common law? So the answer is no. So firstly, when we talk about hierarchy, the first thing comes, that is the supreme law of the land. So Constitution holds the highest authority in the legal hierarchy, reigning supreme over. So Constitution is above statute and common law. So imagine Constitution as the king of the legal world, legal realm, Constitution, and sitting atop a mighty throne. So this is the position of Constitution. This means that if a criminal offence established by Parliament conflict with the Constitution, the courts have the power to declare it invalid. So Section 52 of the Constitution talks about the supremacy. So we call it supremacy clause. It states that the Constitution of Canada is the supreme law of Canada, and any law that is inconsistent, that does not go with the principles of the Constitution, provision of the Constitution, to the level of inconsistency, that particular law will be declared invalid, void, of no force or effect. So this is what Section 65 says. So this position of Constitution, the Constitution, which is the king of legal realm, this position comes from Section 52 of the Constitution Act 1982. So supremacy of statutes comes at second place. So statutes or any law of parliament take precedence over the judge-made common law. So parliament has the authority to override common law, defenses or any presumptions through clear legislation. So for that, parliament has to create a law if the parliament wants to override some common law defenses. Third, constitutional checks. So any changes that are made by parliament here also must align with constitution, because what we read earlier, that ultimately the main authority with which even parliament has to follow and parliament has to take decisions accordingly, go with it, go hand in hand, is the constitution. So for example, parliament's abolition of certain defenses here or fault requirements might be considered unconstitutional if that step taken by parliament violates the rights that are protected by the charter. So everything has to be justified under section 1. So now we are done with sources, then we talked about common law positions, then we talked about the hierarchy. So how are we going to decide that something that parliament has made does not go with the constitutional provisions? So this is where the role of court comes into picture. So as per Kent Roach, the courts play primary role in interpreting the constitution and shaping the common law. At the same time, differences remain because common law, including the way a court interprets a criminal offense or criminal defense, can be displaced by enactment of clear statute. So the statutes, if they limit any charter right, that has to be justified under section 1, which we call this Oakes test. We'll be doing this later in detail. So section 1 of the charter says that charter rights can be limited by law. By law means any parliament's enactment, so long as the limits can be shown to be reasonable, justified, valid in a free and democratic society. So let's suppose parliament has created an enactment, or parliament has taken a decision, has created a law that overrides common law defense. So here parliament has to, if somebody says that okay, this decision of parliament or this law by parliament is infringing my charter rights, my freedom, so parliament has to show that okay, I understand that this might, you might think that this is going to infringe your charter right, but my decision is reasonable because it fulfills section 1's test, because it fulfills the limits that are reasonable in a free and democratic society. So whatever decision I am taking, this is in the best interest of a free and democratic society. So here section 1 test has to be fulfilled. So all these things, all these questions, all these justifications, all these things that have to be proved in the by the parliament, by common law defenses, will be taken up in the courts of law. So this is why we are talking about role of courts, because they play primary role whenever we have to interpret, whenever we have to say that okay, this particular statute, this particular law does not go with the constitution, is against the charter rights, we have to check section 1 validity. So everything is done in the courts of law. So that is why we talk about role of courts here. So in the last, we are going to touch upon another emerging new world source. So we are done with the three main sources, but there is another fourth emerging source of Canadian criminal law, which we do follow here and there whenever required. So that is international law. So international law is increasingly becoming a very major, important, vital source of criminal law. Parliament has responded to this by enacting statutory offences. So now we have crimes like terrorism, war crimes, hate propaganda, torture, all these crimes that Parliament has created align with the international obligation, because we know there are many international treaties, protocols that time and again ask their member countries to enforce them in their particular countries. So we do follow those international laws, and that is why as a result now we have new statutory offences. So Parliament plays a proactive role in incorporating international legal norms into domestic law. So the thing that I'm talking about, that we follow the international conventions, protocols, agreements as member country. So that work of enforcement is done by Parliament by enacting laws. By creating statutory offences that mirror international standard, Parliament demonstrates its commitment to upholding global norm. Courts increasingly draw upon international law to interpret the Charter, statutes, and common law. So imagine a world as a global village where nations are bound by common principles. So just as that, member nations, we respect each other's boundaries. So countries adhere to international laws so that in this global village, we can maintain peace and order. So this is the reason why we follow international law. So now we are done with our whole topic of sources of criminal law. Go back to syllabus once you are done with first topic, any topic for that matter. So go back to your syllabus and just read it once again so that you can revise all the sections, and also you get to know that do I have completed, do I have touched upon all these words, all these topics in my preparation. Then move further to next topic. So sources of criminal law, and you can give it a reading. So this is how I did my preparation. So rest, it's up to you. You can follow whatever method you want to, but this is a like good approach so that you can, imbibe all the things, you can retain all the things side by side. So now let's quickly do revision. So these are my handwritten notes. So these are for revision purpose. I'll be adding these to the notes PDF as well. Also, I'll be taking up in this similar manner all the course lectures. So sources of criminal law. Three sources: constitution, statute, judgment, common law. We are clear. When we talk about constitution, what else we have to read? So division of power, charter. When we talk about division of power, two sections come into picture: 9127, 9214 and 15. For statutes, we go to criminal code, and for drug related, we have Controlled Substance Abuse Act. Then judgment, common law. This we follow only for defenses, contempt of court and interpretation. So section 9 says no to judgment, common law, and yes, section 8 for contempt of court and for defenses. So this is section 8, 2 and 3. So what was the reason why we don't follow judgment, common law? The reason was principle of legality, clear and distinct prohibition, pre-existed prohibitions. So what is the new emerging source? So that is international law. Two important cases: Frey versus Fedrock 1950, R versus Joe Biden 1991. So in Frey versus Fedrock, the concept of peeping Tom came into existence. So it is not defined anywhere in the criminal code. So decision of what is lawful is up to the parliament, not courts. So this case negated the validity of common law offense. Very simple. R versus Joe Biden. So it talks about common law limitations in the implementation. So to restrict, negate a particular offense. So we talked about section 265, assault. So only serious harm can cause or intended, if it was intended, it was caused for consent to be vitiated, so that should be only a serious kind of harm. So not a simple harm can negate your consent in any offense. So this happened in common law, but we don't follow that in our criminal code. So these were the two cases, and these are the all important things that you have to do in your first topic of sources. So see how simply in just one page you can do your revision. So now we are done with our first lecture, demo lecture on the sources of criminal law. So this is the template that talks about the course. So NCA Criminal Law Course 2024. So what you are going to get in this course. So detailed notes, 30 plus video lectures recorded on all topics. So I'll be taking up doubt section separately and answer writing separately. So demo lecture and sample of notes already shared today in this YouTube video. Rest, if you have any query, you can always more than welcome to send me an email on this one, demystifycanadianlaw@gmail.com, or you can send direct message to me by following the Instagram page, Juris Journey, NCA Triumph and Canadian Law. So I'll be making a paid group, WhatsApp group. So whosoever will be joining this course, I'll be adding you to that group. Also, there is a common general WhatsApp group. So send me an email, I will add you to that. So firstly, I am targeting the August 12th to 15th session of Canadian Criminal Law Exam 2024. So the course will be starting from 10th June till 5th August. So these are the dates and the topics. So on these particular dates, you will be receiving the lecture. So like two topics in one lecture. So the lectures will be about like minimum 1.5 to 2 hours, sometimes more than 2 hours. So it depends on what kind of topic we are covering. So you can see 10th June, 11th, 12th, 13th. Then I have given you in between days so that you can go back, you can revise. So this is how you're going to get. So starting from 10th June, then 11th July, 12th, 17th, 18th. So on 20th July, starting from 10th June, we will be covering all 32 topics. Then I'll be taking up two sessions of answer writing practice in which we will be doing the simple long IRAC method questions, then short, because sometimes students feel that if we get 5 marks, 10 marks question, that how do we have to attempt that in IRAC form? How can you cut short your analysis? So I'll be talking about that. Then at last, I'll be taking up a doubt session. So you will have to send me your doubts once we complete the whole syllabus. So I'll be asking you to share your doubts on any topic. Then I will prepare one lecture separately to cover all your doubts. In case any student still faces any issue, then I will solve all your issues personally. So now the details about course. So the price for only notes is Canadian dollar 85, and if you are paying in Indian currency, then it's 5,000 for notes of criminal law. For complete course, including these 22 video lectures, notes, that is 150 Canadian dollars, and Indian currency 9,000 rupees. So if you buy this course, you will be getting $20 flat discount on other subject courses and notes. So for any course related query like payment method details, you can send me an email on demystifycanadianlaw@gmail.com. So you will be getting PDF notes including special content directly from textbook for better answer writing. So I'll be showing you the sample notes now. Then recorded lecture in the form of YouTube private videos. So only students who will buy the course will get access to these lectures. Detailed lectures with revision after every topic. Also, I'll be giving you in the WhatsApp group of paid students, I'll be sharing lecture PDFs so that you can revise side by side. So once syllabus gets complete, you will be asked to share doubts as I told you, so that uh, all your queries get solved. Then you will be added to paid batch WhatsApp group. So these are the notes, Canadian criminal law notes you will be getting in PDF form. So please, it's a humble request, kindly read this disclaimer. Then table of contents, what are topics we are going to cover in the notes. So additional complementary material. So you will be getting 4 hypothetical questions with solution using IRAC method, 1 question requiring legal memo with solution, then smart charts in between for better understanding of concept, and summary of syllabus in the form of storyline. So that I already showed you today. Then general overview and preliminary matter. So I'll be showing you the first topic notes in the form of sample notes. So before every topic notes, I'll be attaching the exact wording from the syllabus so that you don't have to go to syllabus hard copy separately. So see, this is where our first topic starts. So I am directly taking the material from Kent Roach textbook with external material with external explanations so that you don't miss out on any important source for examination. Then, like, I have taken something from Government of Canada's official website, so everything will be mentioned in the notes so that you can refer this in your exam, and it will create definitely a good impression on the checker. So in between I have added these kind of notes. See, this is principle of legality. What does it mean? What does it suggest? So that you can add these things into your answer to make it more impressive. Then this is how you're going to get the provisions. Then contempt of court as an exception, how it's an exception. Then the first case. So what does this case in simple terms says? Then Kent Roach textbook, direct what is relevant. Then what's the position of common law defenses? What all provisions are important? Then R versus Joe Biden case. Then the important lines that you have to take up directly from the book, from the textbook. So I have directly added the screen captures of the textbook so that you don't have to go to the textbook separately and you have everything at one place. Next, there is a question that you have to ask after completing material till this point. Then hierarchy of legal sources. What sections are important under hierarchy? Then what's the role of courts? Section 1. What does Section 1 says? A brief about that. International law as emerging fourth source of Canadian law. So that's all about the first topics. Note. So again, I'm just showing you because I believe in keeping everything transparent, because I know when a student has to invest money in someone, that person should be transparent because I expect the same. That is why I try to give back the same. So that's all for today. I hope you like the demo lecture, you like the sample notes. So if you have any query, again, feel free to reach me through email or through Instagram page. So I'll be sharing my WhatsApp details for further interaction. So that's all for today. Thank you and good luck. Keep supporting and loving. Have a good day.